Hello guys, welcome back to my channel. Today we'll be talking about deed of assignment, particularly the pitfalls that you should take into consideration and avoid when dealing with property transactions. A deed of assignment is a legal instrument that one uses to transfer the person's interests or title or ownership in land or landed property to another person. Simply speaking, a deed of assignment is an instrument of transfer. Similar to a deed of assignment is a deed of conveyance, but under the Nigerian land law, a deed of conveyance is used in some different contexts. Both are basically the same thing in a broader sense because they both transfer ownership or title and interest in landed property to another person. But typically, a deed of conveyance is used over a property that doesn't have a certificate of occupancy. A certificate of occupancy is the certificate that is given by the governor of a state. Now, under the Land Use Act, which governs real estate and landed property in Nigeria, the Land Use Act has vested all the lands in every state in the state governor. So the governor of each state, all lands are vested in the governor of each state. And for the Federal Capital Territory, Abuja, the land is vested in the minister of the FCT. So what applies at the FCT applies to the governors. However, there are some lands that are mostly in the rural areas that have not gone through this proper documentation at the land registries. Once is that sort of property that is mostly found in rural areas, typically a deed of conveyance will be used to transfer one's interests in such kind of property. That is the slight difference between a deed of assignment and a deed of conveyance. So for the purpose of discussion today, we are squarely looking at a deed of assignment. First of all, we will look at the features of a deed of assignment. For any deed of assignment to be valid, there are specific pieces of information that must be contained in the deed of assignment. Typically, when you pick up a deed of assignment, it is customary to put a cover page which just gives a summary of the parties. Now, there are two parties to every deed of assignment: the assignor or assignors, if it's more than one person that is selling the property, and the assignee or assignees, if it's one or more than one person that is purchasing the property. And then you see the name and the MBA stamp, that's the professional stamp of the lawyer who has drafted that deed. Typically, those ones are mere formalities. But for the deed to be valid, the first thing that is important after the cover page is a proper description of the parties. So you will now start with this deed and you put a space for the date initially. Then you start with the names of the parties and properly describing the parties, your full name, because if the name is not consistent with the formal known name of the parties, it could lead to the point of challenging the deed, because one can say Adobe Chizoba is not the same thing as Ades Chizoba. So the names of the parties must be adequately mentioned at the beginning. And then you start with the assignor. So you say Adobe Chizoba as the assignor, and you put the address of the party, a little description. The next part will be the name of the assignee. So the same thing applies. This is the first part of the deed that is key. We now come to a very important aspect. It's called the recital, where you see whereas. So where you see whereas, a recital is now the history of the land. So you're supposed to give a detailed explanation, a detailed history of how the person who is transferring the property, that's the assignor, how the person has adequate title. Now, the deed of assignment aims to protect the assignee, that's the person buying, because you want to ensure that your interests are well covered. You're parting with your money, and you don't want to part your money for something that doesn't have a proper title, or something that is defective, or something that will turn out to be fake. There are a lot of issues with land transactions, property transactions, and some of these things are tied to not doing proper due diligence concerning a purchase of land. So that recital, which many overlook, many don't put into consideration, is a very serious red flag, because you want to ensure that the person that is selling the property to you has a valid and non-defective title. So you want to trace how the person acquired the land, go back to the history. Now, if there's a certificate of occupancy on that piece of property, there will be no need to go to the original history of the land, like from the cradle when it was owned by the initial family. So this is a very, very important aspect in a deed of assignment that many overlook. These things are overlooked when people just think, oh, they can just take a deed of assignment that is not just copy and paste, and you just pick up a deed of assignment and you want to adopt it for yourself without going through proper legal counsel. So it's one area that you should always look out for in any deed of assignment, especially for you that is the purchaser, you that is the assignee. You want to make sure that your assignor has adequate title and can trace it to the person. After the recital, the next part will go into the part that describes the property, particularly the amount, the agreed amount between, because before the deed is drafted, there would have been negotiations. So the agreed cost of the land will be stated in the next paragraph. At that point, the deed will state that the assignee or the purchaser has paid the agreed amount to the assignor, which the assignor now acknowledges. And then also in that paragraph, a description of the property, proper description of the property will be stated. So you state the exact location, anything to just properly demarcate and distinguish the property. If there are boundaries, notable boundaries, it is bounded by beside the mobile filling station or beside whatever. So you explain the location of the property in very clear terms that are distinguishable. It's also to avoid situations that could lead to ambiguities where the location of the property is in doubt and is uncertain. Then, while describing the location of the property, you also now include the size of the property. And typically, before the deed of assignment is drafted, you would have done a survey plan. It was one important thing that should be done by a buyer. You don't just take the word of the assignor or the seller like that, oh, this land is 460 square meters. I mean, you do a proper survey by a surveyor, a licensed surveyor. So, and then you now state the survey plan number, because those survey plans are also registered in the office of the Surveyor General. So all this will be contained in that same paragraph. Afterward, the next paragraph will now contain the covenants or the undertakings that each party decides, whatever they have agreed to do. That paragraph will now state that the assignor covenants to indemnify the assignee for claims, for adverse claims, if there are any adverse claims that now arise by a defect of his title. So you are trying to just cover all the grounds to ensure that you as an assignee, you are properly covered. So you state that the assignor covenants to indemnify the assignee of adverse claims, if any. And so, assuming assignor hasn't acquired a certificate of occupancy over the property and the assignee wishes to acquire a certificate of occupancy over the property, the assignor can also undertake to assist the assignor with all things that are necessary and required, every document, every material information, everything that is required to process the certificate of occupancy. So the parties will just generally agree on whatever they want to agree to ensure that the assignee gets full value or gets his adequate title and get full value for his money. The assignor too also his or her own covenant that he also undertakes to, going forward, pay all the ground rents that are applicable, and make anything that is just valid, anything that the parties agree that is an outstanding that should be done, will be contained in this portion of the agreement. So right after the covenants of both parties, you will go to the last section of the deed, which has the signatures of both parties and the signatures of their witnesses, the name and the signatures of their witnesses. The witness part is a very important part of the document. Typically, if it's a company that is entering into the agreement, a director and secretary of the company will sign, or two directors, because by law, two directors are required to sign on behalf of a company, except in a case of single member or single director companies, which has been recently introduced by the Companies and Allied Matters Act 2020. So in such instance, the authorized representative of the company can sign. But if it's an individual, just one witness is enough for the individual. So now you include the names of the witnesses, include their signature is important, then their addresses are also important, then probably their occupation is also important. It's just an extra layer of proof for external parties to testify to the fact that the two parties, the assignor and the assignee, have entered into that agreement, and the assignor especially has to sign for it to be valid. The two parties have to sign, but particularly as the assignee, you must ensure that the assignor signs it. As an assignee, I mean, you have the document, you can sign it at any time you want, but before the whole transaction is concluded, you must ensure that the assignor's signature is on the document. This is usually the end of the document, because you wrap it up with the signatures of the two parties, the assignor and the assignee, and as well as their witnesses. Now, there's an additional thing, which is the part for the governor's consent, which is just part of the requirements to ensure the validity of your document. So this takes us to the next subheading we'll be looking at, which has title Perfection of a Deed of Assignment. By virtue of the Land Use Act, Section 22 of the Land Use Act, which is applicable in Nigeria, the section prohibits any sale or any transfer of any interest, including mortgage, a full sale or a mortgage, any transfer by whatsoever means, from one party without obtaining the consent of the governor. So that section prohibits any kind of sale or alienation of your interest where you have not obtained the consent of the governor. So the consent of the governor's consent, is just an extra layer that puts the government as a witness to your transaction. So you're supposed to obtain the governor's consent, which is an authorization to transfer the property. So for perfection of title, as the name implies, you're to perfect your title or perfect your deed of assignment. There are three main steps. This governor's consent is the first step. The second is called stamping, while the third is called the registration. And in our legal parlance, we refer to them as CSR. Consent, stamping, and registration. After the consent of the governor has been obtained, the second step towards the perfection of your title in a deed of assignment is the stamping. Now, stamping is just a tax. The stamping refers to the stamp duties that will be paid while a stamp will be affixed to your deed. Stamp duties is a form of tax that is applicable to legal instruments. Documents could include a deed of assignment, a deed of gift. It could also include the power of attorney. It includes power of attorney. It even includes some kinds of receipts. By virtue of the Stamp Duties Act, there are a list of documents that require stamp duties to be paid. So a deed of assignment is one of those, and you pay 1.5% of the value of the property for a deed of assignment. So for stamp duties, some of those legal instruments that should be stamped, some are fixed, like an irrevocable power of attorney has a fixed amount that will be paid as stamp duties. But for a deed of assignment, a deed of gift, a deed of legal mortgage, the amount that is payable is ad valorem. That is based on the value. It's not fixed. It's the opposite of being fixed. So for deeds of assignment, the percentage is 1.5% of the value of the property. Now, this doesn't mean that you can now go and undervalue the property so that your stamp duties will be less. Usually, the Inland Revenue Services have a schedule, and they know how much land property should go for in so and so area, in specific areas, and based on the improvement of the property, they know what the amount, the value should be in that area. So, and also based on the improvement here means if the land has been developed, if it has buildings and all that. If the parties are individuals, it's the state inland revenue service that you pay the stamp duties to. But if one party is a company, whether one or two, as long as one party is a company, whether the Assignor or the Assignee, once there's a company involved, that goes to the Federal Inland Revenue Service. But the Federal Inland Revenue Service has offices in all the states in the country too, including the FCT. So you typically have the State Inland Revenue Service of your state alongside an office of the Federal Inland Revenue Service in your state. So depending on the parties, you know the particular agency that you make the stamp duties payment to, and once the payment is made, it cannot be refunded. So that's why you need to know where you're supposed to make the payment, so that you avoid losing your money by paying into the wrong place. This now leads us to the third step, which is the registration proper. Registration is the aspect that entails registering the details of the transaction in the appropriate land registry. So each state in the country also has a land registry, including the Federal Capital Territory. Therefore, in the same way you make your stamp duties payment at the relevant inland revenue services in your state, you also go to the land registry of the state where the land is located to register the transaction. Now, this registration process, you also pay the fees. Each step, like I said, for the consent stage, there's a fee you pay, but those fees are minimal. It's the stamp duties fees that is based on the value of the transaction. But for the consent and for the registration, the fees are usually minimal depending on the state involved. So you make the appropriate payment, the necessary submissions at the land registry, and typically at the end of it, this will take months depending on the state and how fast they are and the volume of work that they have. So typically this registration could take the longest of time, just as it is with the consent. But at the end of the whole procedure, there will be a stamp from the land registry, and it will now allocate a number, a registered number of the property in the land registry. So the essence of this registration is, as the name implies, to perfect your title. Now, this acts as public evidence, public notice that this transaction has been done. So the land registry is a registry that contains all transactions pertaining to land, whether it's a sale, an assignment, or a mortgage, a long-term mortgage, or whatever it is. So even if the mortgage has been settled, you go back to the land registry, and it will also now reflect that the title has gone back to the original owner, the mortgagor. So every single transaction is recorded there. Now, this is why it is important, because as you have registered your property there, it's a notice to the entire world that this transaction has been done. And this is one of the areas that one can make adequate due diligence before a property is acquired. So typically, if you want to acquire property, like I mentioned earlier, you're supposed to have conducted due diligence, and one of your first port of calls is the land registry if the land has been registered there. Now, a pertinent question is, if your transaction is not adequately registered, what are the pitfalls? Does it make your transaction or your deed of assignment invalid? The answer is no. Not registering your property doesn't make it invalid. However, the pitfall is if the deed of assignment is not registered. For one, you cannot tender the deed of assignment in court should a matter arise. For instance, if there's an adverse claim and there are 2 or 3 people that have bought the same property with you, or for some reason there's a dispute in court, you cannot tender your unregistered deed of assignment as evidence in court, because it is inadmissible based on the laws of evidence in Nigeria. So that is a major reason why registration is important. And the same way, stamping is also important, because if you don't stamp, you cannot register. Like I said, those steps must be followed for the perfection in the consent, the stamping, and the registration in that order. So if you don't stamp, you can't register. And your document also will be inadmissible. Another pitfall, if you don't register your deed of assignment, is that you will lose priority, because if a subsequent purchaser goes ahead of you, register that same property at the land registry, the person takes priority over you. It doesn't matter if you bought yours 20 years before the second person bought. Probably there was some fraudulent stuff and the seller still sold that same piece of property to another person. As long as that second person gets it registered at the land registry before you, the person now takes priority in court. Remember that you cannot even tender your own in evidence. So that person takes priority in the eyes of the law, in the eyes of the public, over you. What you have at best is called an equitable interest, and what you can do at that point is to go after the sellers. Then the last advantage of registering your deed of assignment is that it tells you that the property is not encumbered. So like that subsequent purchaser did not see any registration, any prior registration there when the person did a search. So the person went ahead to buy because there's no registration. So registration gives you the assurance that the title is not encumbered. It doesn't have any adverse claims or adverse interest. It's a major aspect of land transactions that is overlooked because people just purchase property, sign deed of assignment between them and the sellers, and just go to sleep, not knowing that there are adverse risks associated with their failure to obtain the governor's consent, stamp and register the property. In conclusion, before you execute a deed of assignment, ensure that you go through the whole hall of carrying out due diligence, ensuring that the property is not encumbered. You also undertake physical searches of the property, go around and do inspections, ask questions from neighbors and the rest, do the appropriate searches, even in courts, because the issues surrounding the ownership of the property could be contested in court. So going to court is another place to check for the validity of the seller's interest. All these have to be put in consideration, including perfecting your title, that is obtaining the governor's consent, stamping and registering your title. These ought to be considered when executing a deed of assignment, particularly by the assignor or the assignor stroke the purchaser. So if you have any further questions, you can comment in the comment section below. And if you found the video useful, kindly like and share and subscribe to the channel. And then I'll see you in my next video. Thank you. Bye.